Good evening, welcome to everyone to the planning board meeting for Monday, May 5th, 2025, regularly scheduled meeting of the East Bridgewater Planning Board. In attendance tonight and acting on behalf of the board, we have our regular members, Diane Phillips, Rachel Tedesco, Roy Gardner, Miles Heeger, myself, Kevin Riley, and we have our alternate member, associate member Yvonne McCrae as well. Busy agenda tonight, a number of things to go over. Start off, there are no minutes for approval tonight, so we'll move right into the Form A application for 453 Bridge Street. That is an application that was submitted by Mr. and Mrs. Sexton through, I believe it was Pilling Engineering, that created Pilling Land Surveying, excuse me. They would be creating from the existing property at 453 Bridge Street. They would be creating a lot of approximately 15,242 square feet, which would be joined to the premises at 2 Dolphin Drive to basically give that a little bit larger land area. They are related parties, I believe parents and daughter. Plan was presented. It has the appropriate notations on it relative to zoning and so forth, and the fact that the lot will be combined with the existing number 2 Dolphin Drive. Comments, questions with regard to this, Mr. Gardner, anything from your standpoint?
Yeah, we have to have them change the title of that parcel 2B-1. The term lot is used on the plan. It's not a lot. By definition, under zoning and under our own zoning bylaw, that's a parcel where a parcel of land is some area of land that's not suitable for building in and of itself, as it doesn't have legal frontage to meet the requirements to be a lot. And lots can't be created on Form A plans, only parcels can be. So we need to get that titled, it's in the upper right-hand corner, left-hand corner, I'm sorry, right there. That needs to say parcel 2B-1. So, Pilling Land Survey will have to correct that. I could cross it out and initial it, but the Registry of Deeds doesn't like us to do that, so. Other than that, I think it looks fine. It doesn't create any new lots. It does square off some lot lines based on what the plan shows, so.
Roy, do you know, just out of curiosity, the access to 453 Bridge Street? It looks like it's a sort of a undeveloped or.
Yeah, 453 Bridge Street, legal frontage comes off of Dolphin Drive.
Right.
Dolphin Drive, I believe, is a one-lot subdivision that was created back in 86, 87 timeline, I believe.
It looks like it was intended to have a cul-de-sac access, or whether that's the sort of what's there now on the ground.
That's physically what's there.
Physically what's there, okay.
Yes.
Yeah, all right, perfect. Okay. Okay, so do we want to entertain a motion to approve with the change made, or to authorize execution of the Form A plan for 453 Bridge Street, 2 Dolphin Drive, once the verbiage is updated from parcel, or to parcel from lot?
I'll make the motion to approve with the changes as presented.
Motion is made by Mr. Heeger. Second to that motion?
I'll second that.
Seconded by Mrs. Tedesco. Further discussion? Hearing none, all those in favor?
Aye.
Aye.
Aye. Any opposed? Let's vote of all members present and voting. We'll bit before, yeah, we have a few minutes. Mr. Macy is here with regard to Layla Estates. Mr. Macy, come up if you will, just if you have any update for us with regard to the matter of the street lighting.
Good evening, everyone.
Good evening,
My name is
sir.
Mr. Macy. I was asked to come in front of the board regarding street lighting at Layla Estates. From about maybe 2 weeks ago, from when I provided an update via email, nothing much has changed. National Grid's probably one of the slowest establishments, if I could say, to deal with. Just to kind of recap, I previously talked to Mr. Gardner about it. He had suggested maybe that I talk to the residents, because I guess they had come and had some concerns on the streetlights. We had a meeting with everybody in the residents and asked, you know, to see if maybe they were open to, you know, certain, not streetlights, but lanterns on the driveway but ultimately they said they wanted streetlights. And that was something that Roy had mentioned, maybe depending if they wanted something different, then we could get writing from them, come to you guys and just have a discussion. That didn't go. I gave them both options. I told them that the National Grid route to put streetlights in was going to take a while. They understood. I was pretty transparent about that. And as soon as I have some kind of plan or something from National Grid, they usually give a trench sketch of where it's going to go. I'll pass that on and I'll send that to Candy. So don't really have any new news. Maybe within a month or two they get back to you. I mean, typically the next step is I'm going to have to go to the DPW director too. They're going to give you a street form that just talks about the light, and usually the DPW director has to sign that and then get that back to them, acknowledging that there'll be street lights. And that's pretty much all I have regarding that.
Okay, so we know, obviously, that the process is in motion. I think that as long as we keep a line of communication open and, you know, kind of keep moving forward.
Sure.
You know,
Happy
I
to
think
do so.
that's the goal here. Guys, any thoughts or questions for Mr. Macy while he's here?
Yeah, if we could, I would like to get something in writing from Mr. Macy that is clear that National Grid is working on this.
As
So
soon as
that
I get,
we have the ability to give something to the residents to show that National Grid is actually in the process of doing something.
well, that's already what I've done via email. So once we have a
Is
trench,
National Grid copied on it? I didn't see National Grid copied on the one I saw, I didn't think, but.
No, it was just to the office that I know.
so yeah, so once we have a trench sketch or the work request that they're populating, again, it's like I said, I'd send that all to you.
Have you made a written request to
The
National Grid?
National Grid, we've had three conversations with them.
Have you made a written request to National Grid?
It's actually not, well, via email, yes, but there's not like a
Will you
written.
send us a copy of that, please?
Sure.
Because National Grid doesn't officially act on anything unless you make a formal request for a
Oh,
connection.
I'm well aware of National Grid
That's
doesn't
why,
do anything.
and we haven't seen one, and two of the residents have spoken to me and said they haven't seen anything.
Sure.
that
That was
that's
only,
going on as well.
only within the last few weeks since your last email.
All right, so let's get a copy of that into the office.
Not a problem. Anything else?
Any other questions?
No,
Comments?
no,
No?
I'm good.
Okay, appreciate the
hope
update.
everyone has a good evening.
We'll
Thanks for
continue
your
to
time,
follow
guys.
up. Thank you. Okay.
4 minutes to wait.
Mr. Gardner, anything to fill 4 minutes?
No, I just think I'd like to make sure all the board is aware that, that somehow one of the three zoning articles we had proposed back earlier this year, as early as first week of March, I believe, when we asked for reservation of articles, is missing from the warrant. It is in all the emails. It is posted on the website. The language is posted on the website. There is 3 articles in the warrant. One of the problems I just noticed tonight when I saw it for the first time, the printed copy of the warrant, is that the MBTA-2025 proposed zoning bylaw change, for the second time, despite advice from the state group that I've been working with, they stripped the map out and put the map in as a separate article. According to the state, for the zoning article, strongly suggested that that be done as a single action. So while it does appear there are 3 planning board zoning articles, they're not in the format that we requested, and what we thought was gonna be the 3rd one is missing. So there's already been an email written a few minutes ago to the Board of Selectmen, as well as the town administrator, advising that we need to talk about that.
And that is the last of the public hearings tonight, the B3 zoning amendment, the proposed B3.
That's the 8 o'clock public hearing tonight.
Okay. Is it something you can add on?
I have no idea how the
We'll
warrant,
hold the public hearing, and we'll see, you know, where we can go from there. That's kind of what the intent is. Okay. It being 7:15, we have the first of several public hearings tonight. That is with respect to a proposed amendment to section 67 of the zoning bylaw, excuse me. That is with respect to accessory dwelling units. I will open the public hearing at 7:15. Read the legal notice. Town of East Bridgewater Planning Board, notice of public hearing. Planning Board of the Town of East Bridgewater will hold a public hearing on Monday, May 5th, 2025, at 7:15 PM in the Town Office Building, 175 Central Street, large second-floor conference room. The purpose of the hearing will be to review a proposed amendment to Section 67 of the zoning bylaws of the town to permit the construction of accessory dwelling units consistent with the provisions of Chapter 150 of the Acts of 2024, the Affordable Homes Act, so-called, and the planning board seeks public input relative to this proposal. The full text of the proposal is available for review at the Planning Building Department during the hours of 8:30 a.m. to 4:30 p.m., Monday through Thursday, 8:30 a.m. to noontime on Fridays. And that was published as required in the Brockton Enterprise, excuse me. Sorry. So just by way of a little bit of background, for those in the audience who might be interested with this, this is a matter, we actually did a revision to our bylaw at the special town meeting in the fall, kind of anticipating what was coming from the state. We did get some guidance back from the state that there were some issues with the provisions, and there was some new terminology in what the state had actually put out in the way of suggested guidelines. So we are modeling the revision here after what the state guidance has come out as being. So it is essentially, in many respects, the same proposal, just updated to respect what the state guidance has been, so as to assure that the new bylaw will be approved by the Attorney General. So for purposes of the public hearing, we will, as normal, we will open it up to the audience. If you do have comments or questions, as with all of the public hearings tonight, I'd ask you to state your name and residence, and then make your comments. Try to keep, if you will, to about a 3-minute time frame, and we'll do our best to answer any questions that we can. And with that, open it up at this point to any public comment in regard to the ADU article. Second time, yes, sir.
Want me to come up there or just,
Whichever you prefer, as long as you speak up.
Oh, sure, I didn't have any intentions of speaking.
Name and address, sir?
Ken Feinberg, 2 Jacqueline's Place.
Thank you.
When I bought the lot 30-something years ago, it was an oversized lot, and I was content to have the lot on the side there. I knew it wasn't buildable because the lot isn't big enough for two homes. When I heard about the ADU and the purpose of it, in my particular instance, it's exactly what it's meant for. My daughter, who's a lifelong East Bridgewaterite, wants to raise her family in East Bridgewater, but currently can't afford to buy a house in East Bridgewater. The cost of land is outrageous. Under this new, under the ADU now, we believe we're able to use that lot, provided it abides by all the setbacks and everything. And she's gonna have the opportunity to live in East Bridgewater, raise her kids in East Bridgewater, go to schools in East Bridgewater. And I just wanna say that when used properly, I think this is a wonderful change in the bylaws so that people can now afford to build a house in East Bridgewater that might never be able to do that before. That's all.
Appreciate the comment. Further discussion from the audience? Mr. Silva?
Hi, I'm Lawrence Silva from Silva Engineering Associates from Bridgewater. I just wanted to just make you aware that we've had some go-arounds, and we've had some clients that have been involved with some townships that have been taking issue with the bylaws. And in particular, the issue that they seem to have a problem with is that the state has sort of defined what qualifies as being not just a single-family home site, but if it has a multifamily on it, it was still entitled to an ADU. So I would say, if you get a chance, look at some of the more recent guidance that's come from the state, because it seems to have conflicted with what we all thought was the limitations on where it could be applied. And I know that there was some letter that just came back. I didn't know if it was in East Bridgewater or West Bridgewater, where the state just responded saying that they couldn't preclude an ADU on a property because it had it was a multi-family kind of situation, and they said that it still applied to it. So I would just, I noticed your language was pretty clear, the way most of them have been, of having it being on a, a single-family house lot or in a particular R1 zone. But you might want to just double-check some of that to make sure you don't get caught in that kind of trap.
So if I could respond to that, Mr. Chairman. This is actually the language directly from the state.
I know, and that's what a lot of them used, but then
So my only comment, and I think we'll end the discussion at
Yeah,
that
okay.
point, is that the state law, which is only a couple of paragraphs, clearly says multiple times, at least 3 times, single family.
Right.
The state has to use their rules and regulations to be in compliance with single family. So we're not gonna debate this at this meeting. If we get a letter back saying that's not what we want, then at that point, we will respond to the state. Because I had a long discussion with our former building inspector, who is right now the building inspector in the town of Bridgewater. And he said the same thing. The state is clearly starting to give guidance that runs completely counter to the enabling legislation. So my opinion is if they want to do that, and they can keep modifying their rules and regulations, that violates the same law that the state Supreme Court said they violated with the MBTA zoning district. If they want to change their rules and regulations, there's a proper way to do that through public input, which isn't, these are on the fly, supposedly changing.
Absolutely, I totally
So
agree.
we don't have any way to address that at this point. We use the language that the state had originally published with a link to planning board saying, use this one.
Right.
So I don't know where to go with that, so.
Fair enough.
All right, third and final time on the, yes, sir.
Rich Ferrioli, Summit Drive. I might have missed something at the beginning of the meeting, but how do you work the septic in these situations?
Needs to comply with Title V regulations.
Well, I mean, if you have a piece of property that's not conforming, and you're gonna try to build on it, can you still put the septic system, or does the septic system still fit or work in this situation?
Let me try and address that. So I'm gonna answer that question because, for better or for worse, I'm doing this in the town of Foxborough at my daughter's house for my wife and I. So the rule is extremely clear. You have to go independently to the Board of Health with a sketch of what you wanna do, Most towns, that sketch has to be done by a surveyor. It has to include formal meets and bounds. And that septic plan has to be done by an engineer. And that plan has to be submitted to the Board of Health and has to fully comply with Title V. So that's totally independent of the land use part that the planning board does. And one last comment to the gentleman who spoke a little earlier. Just a reminder that the ADU is limited to 900 square feet or half of your existing home, whichever is the smaller number. But that's perfect for, in my case, that's perfect for my wife and I. It's usually perfect for, I don't want to say old, but a senior citizen or citizens that want to move on to a smaller living space and still protect the value of their property for their family. So,
You're out of order.
All right, third and final time for comment from the audience. There being none, Chair would entertain a motion to close the public comment section of the hearing.
So moved.
Motion is made by Mrs. Phillips. Second to the motion.
I second that.
Seconded by Mrs. Tedesco. All those in favor of the motion to close the public comment
Aye.
and opposed? So voted. At this point, comments, questions from the board?
My only comment is that it makes a lot of sense to allow ADUs. I think we need them. We need more housing opportunities, so I support this.
Same, and I appreciate the gentleman in the back and his story that resonates with many families in town. So,
Vaughn?
thank you.
Comments?
Yeah, from what I'm reading, if you have a basement, can it qualify as an ADU if you want to convert it?
You can modify, you can extend, or you can build separately.
Yeah, I have a basement, that's why I'm asking.
I think that the actual answer to that, Yvonne, will be whether or not the basement can qualify as residential living space under the building code. So you'd have to check in the town, obviously here in East Bridgewater, you have to check with the building inspector with some kind of a sketch as to what you want it to do.
Okay.
And then he could tell you whether that would meet building code in terms of access, egress, window heights, all those other kind of things that are part of the building code.
But, you know, in terms of an ADU, it is available to you. Miles? No? Roy?
No, I'm good.
Okay. Chair would entertain a motion?
All right, so I'll make a motion that we make a recommendation at town meeting that we adopt the proposal ADU bylaw with one additional small note. It appears that the short-term rental requirement, although referenced in the definitions, the number didn't get in there somehow. And I think we had decided at the previous meetings that we wanted a short-term rental time not to be less than 90 days. We had put in a prior bylaw, I think, a year, and that was quashed by the Attorney General's letter. Suggestions from the state website seem to indicate that a 90-day time period would be accepted.
What we have is 120.
Where is that? Because I couldn't find it.
12I. I thought 12, 12-1, 12 sub 1. 120 consecutive days or less.
Is it in there?
Fifth line down.
Oh, yes.
Page
All right. All right, then I'll live with 120, because I do think that was the number we came up with before the Attorney General's letter.
Okay.
So let's live with that, and if they don't like that, they can move it back to 90 days with the approval.
So the motion is made by Mr. Gardner to recommend to the annual town meeting the approval of the revision to section 67, the ADU bylaw. Second to that motion?
I'll second that motion.
Seconded by Mrs. Tedesco. Further discussion from the board? None. All those in favor, so signify by saying aye.
Aye.
And opposed? Unanimous vote of members present and voting. Okay. Take a moment. It being 7:30, public hearing regarding so-called MBTA community zoning. Declare at this time the public hearing to be open. Public notice, legal notice, Town of East Bridgewater Planning Board of the Town of East Bridgewater will hold a public hearing on Monday, May 5th, 2025 at 7:30 PM in the Town Office Building, 175 Central Street, large second-floor conference room. The purpose of the hearing will be to review a proposed amendment to the zoning bylaws of the town whereby a new section entitled MBTA 2025 Single and Multifamily Overlay District, or MBTA OD, would be added. Proposed MBTA OD would allow construction of single and multifamily housing and/or mixed-use development as a matter of right in accordance with the requirements of Mass General Laws, Chapter 40A, Section 3A. Planning Board seeks public input relative to the proposal. Full text of the proposed zoning bylaw amendment, together with plans which illustrate the area which would be included in the MBTA OD, are available for review with the Planning Building Department during the hours of 8:30 a.m. to 4:30 p.m. Monday through Thursday, Friday, 8:30 a.m. to 12 p.m. And again, these notices were published in the Brockton Enterprise on 21st and 28th of April. So as previously, we will go through the public hearing process. Again, just in terms of a summary, this, you may recall, was something that was brought up again at the special town meeting last year. We had a number of discussions, public hearing and other meetings last year before this board. And ultimately, the zoning article was turned down at the special town meeting. That zoning article contained two proposed areas, one being the central district, the so-called brownfields area in the center of town, and also the north district, which is the area up by the town of Whitman town line. This proposal, while it does many of the same things, limits itself to the area of the north, what was the north district in the last proposal, so the area up by the Whitman town line, bordered by Route 18 and Winter Street as well. Essentially, the changes that have taken place since we last discussed this, number one, the matter that the town of Milton had brought challenging the constitutionality of the MBTA Communities Act was decided by the Supreme Judicial Court in January of this year. The court found that the law itself was constitutional and its provisions could be enforced by the Attorney General. However, it found that the process by which the regulations were adopted was somewhat flawed, so that the state has gone through a new process to implement or to have enacted those regulations. The towns, cities and towns that were non-compliant were given a period of time to submit an action plan to the state as to how they would come into compliance, and then also given an additional time to come into compliance, that is by way of amendment to the zoning bylaws to evidence the fact that a district or districts had been created conforming to the MBTA Communities Zoning Act. That deadline is in mid-July of this year, so the town meeting will take place in May, and assuming that this were to pass, we would be in compliance with the state requirements. You will recall that the MBTA communities, as we discussed last year, is not a quote-unquote low-income type of development. It is an affordable housing development. It is intended to it's not an affordable housing. It's intended to have a higher density development to allow an increase in housing in response to what has been perceived as a housing emergency in the state of Massachusetts. So you'll recall further that the area, or a portion of the area that would be rezoned, which Mr. Gardner has up on the displays, portion of that area is the area that has been approved for the development of 220 units of mixed condominium and apartment dwellings under the 40B proposal that was recently decided by the Zoning Board of Appeals. So that 220 units is already on the books. This would be a little broader area, but it would, again, bring the town, assuming that the article is approved, into compliance with the requirements of the MBTA Communities Act. One of the folks who has done a lot of work to help the town of East Bridgewater with this go-round is Mr. Jason DeRozier from OCPC. Jason is here tonight, and he can help us answer any questions that you may have. He's done a number of public forums. He's done some informal coffee house meetings, and hopefully some of you who are concerned about this one way or another have had an opportunity to speak with him independently and have your questions and concerns addressed. So at this point, we'll open it up to the public. Again, if you'll give your name and address, keep your comments to a reasonable limit, and also if you could, if you know, your thoughts or ideas have been already expressed, perhaps just let's not be repetitive to the extent we can keep things moving. So at this point, open it up to the audience for public comment with respect to the proposed MBTA Communities zoning amendment. Second time, public comment on the proposed amendment. Sir.
April Heat, 103 Branch Road. How does this become broader than what was already proposed for development for the JSC Holdings? I believe the town was East Bridgewater land that was, is that gonna be built upon? Or in the zoning? I shouldn't say built upon, that's the wrong phrase.
His question.
Yeah, I mean, it's 96 and 7, right? And 123, I think those.
I can
three
answer that.
Yeah, go ahead.
Yeah, so the reason the land is slightly bigger is because the Attorney General's office has given us guidance that we need to have at least 50 buildable acres. When we removed the downtown district, that removed a substantial portion of the land that we had put together for the two different districts to get us to 50 buildable acres. So in this one, we added districts 109.7 and 109.6, which are town parcels.
Town of East Bridgewater, correct?
Those are town of East Bridgewater parcels. Now, the rationale behind that is that there's somewhere between 40 and 60% wetlands overall in those parcels. So those parcels total out to be, I believe it's 118, 119 acres, close to that. If you take 40 to 60% wetlands out, it gets us just above the minimum 50 acres that we have to show. So that's why the size of the district was expanded. And you are correct in that land also encompasses what's been approved as part of the 40B for the Meadowbrook application.
When that was approved, we were supposed to have access as townspeople to the town land, to the 40B project. That's the way it was sold to the town.
We do actually have access. JSC Holdings conveyed a piece of land to the town
But now,
so that we
that's
have
when it gets
access to
built
that.
upon, it'll be gone, correct?
No. They conveyed a piece of land down here off of Route 18 for access. It's actually been conveyed to the town,
Okay.
and it goes out to Route 18.
Further comments, questions? Third and final time, any comments, questions with regard to the proposed zoning amendment?
I have a question on the matter. Donna Mashazek, West Union Street. On this piece of paper here, it talks about the 11 parcels that are involved. And it says 109.6 and 109.7, but I don't see them on this map.
109.6 and 109.7 are,
Not on this one.
what you mean? 6 and 7.
Bottom two.
Over to the right?
They're the bottom two parcels.
Yeah, bottom
Oh,
two
okay,
pieces.
okay, I couldn't see it. Did it cut off on
That's the
here?
town-owned area that Mr. Gardner was just referring to. Third and final time for questions, comments from the audience. Hearing none, Chair would entertain a motion to close the public comment section of the hearing.
So
So
moved.
moved.
Motion, Mr. Gardner, second, and Mrs. Tedesco. Discussion, none. All in favor, so signify by saying aye.
Aye.
Opposed? Unanimous vote. The board, ladies, questions, comments, general?
Well,
Diane?
no, I think we've, really looked at this for a year and really have worked really hard on that. Thank you for all that have done that. I think it's been a great process, so I'm ready to move.
Rachel?
I think that takes into consideration all the needs of expanding housing opportunities, and balancing that with protecting the environment, with protecting the wetlands still. So I think it's a good plan. I think it will work out in our town.
Yvonne?
Oh,
Nope. Miles?
I'll just say, I know from listening to a lot of people in town, it's been shot down once at town meeting. People are not thrilled still, so that's an issue that we're gonna have to face as a board, when it comes to it. I mean, I'm gonna vote no tonight, just my personal opinion. I know a lot of people in this town do not want this change to town, and it's a risk we'll have to take as a board with a vote, but I'm opposed to it.
Right.
I don't have anything further to say. I think the message from the state is clear. Current adoption rate as of this morning, of the 160 some odd towns, 128 have adopted it, only 2 have voted it down, as of what I could find on the state website this morning. So it's pretty clear that the Attorney General's office and the guidance they're given to the towns are, you're gonna do this or we're gonna enforce it directly. So my opinion is always that if we're gonna have a chance to adopt a bylaw that we've written, better off than having the Attorney General's office do that for us. Because he's made it clear, they've made it clear in the guidance that they will enforce it and make us do it through some mechanism. The mechanism's not totally clear, but they can simply change the state zoning act that requires it, which they've already done with the ADUs. They actually put the requirement for us to allow ADUs into the state zoning act directly. They certainly can do the same with the MBTA zoning if they want to do that.
I mean, I think, I look at loss, I mean, we've been tasked with coming up with this plan. And the loss to our town would be within grants and with monies, I think, and this is not a time to lose money. I think as a board, we've looked at this and come up with a plan that we feel is safer, it's the best option for our town. I like that you brought in the wetlands and the environmental, Rachel. I think we've done a really good job, and, well, we, mostly Roy, thank you. I don't think, if 128 towns have voted it in, and it's only 2 that have opposed it at this point, I would hate to be the 3rd town, because I think they're going to be made to lose funds to our town, and that's going to be a scary thing.
Agree with that.
For myself, I would say, it's again, as Diane is indicating, it's a question of cost of compliance or non-compliance. I think there is a significant risk that the town takes in terms of potential loss of funds. I think the other thing that is important to distinguish here is that this is, and I think these were the words that Jason used last week or 2 weeks ago, maybe at one of the forums that I attended that he had. It's more of a zoning exercise, right? The fact that this would pass doesn't mean that a single unit of that housing has to be built. All it means is that the town has made provision for it to be built. There is no guarantee that it will or won't. So I think based on that, given, you know, setting that off against what the potential costs of not complying would be, you know, I think that the best interests of the town would be to move forward with this. And I think, you know, it's in a limited area. Certainly a good portion of it has already been targeted for development, and whether or not any additional units would ever be built in that area, who knows? But it is, I think, a necessary evil for the town of East Bridgewater. Let's put it that way. Further discussion from the board? There being none, Chair would entertain a motion. Mrs. Tedesco?
I move that we, what am I saying?
Recommend adoption
We
of the...
recommend adoption of the proposed zoning bylaw for the MBTA community zoning.
Second.
So motion is made by Mrs. Tedesco to recommend to the annual town meeting the adoption of the proposed zoning bylaw amendment, which would create the MBTA overlay district. And as a component of that, to adopt the map that has been proposed and is displayed this evening. And that motion was seconded by Mr. Gardner. Further discussion on that motion? There being none, all those in favor of the motion so signify by saying aye.
Aye.
And opposed.
Opposed, no.
That's a vote of 5-1, Mr. Heeger, rather, in opposition. That public hearing is closed. Okay. Thank you for your thoughts and comments, by the way, in the audience, too. And again, Jason, I thank you for your efforts in helping the town. Much appreciated, and certainly not unrecognized. It being 7:45, we have a further public hearing, this one with respect to property at 1968 and 1972 Plymouth Street. Chair will declare the public hearing to be open at this time. Public notice, legal notice, Town of East Bridgewater Planning Board. Planning Board will hold a public hearing Monday, May 5th, 2025, at 7:45 PM in the Town Office Building, 175 Central Street, large second-floor conference room. Purpose will be to review a Form B subdivision application and plan submitted by Silva Engineering on behalf of Edward and Beverly Smith. The applicant is proposing a two-lot subdivision. Subject property is located at 1968 and 1972 Plymouth Street. Zoning classification is Residence 1. Property is shown on zoning, or rather Assessor's Map 1, Block 4. The Planning Board, as required by the Town of East Bridgewater subdivision rules and regulations and Mass General Laws, Chapter 41, Section 81T, seeks public input relative to this proposed subdivision. The plans are on file with the Planning and Building Department and can be reviewed during normal business hours. So with respect to this public hearing, we'll have the applicant and/or representative make a presentation. We'll take further public comment on the application, and then we'll open it up to the board for comments and potential action this evening. We have the dapper Mr. Silva here on behalf of the applicant. Mr. Silva.
Good evening.
Good evening.
My name is Lawrence Silva from Silva Engineering Associates. Offices at 1615 Bedford Street in Bridgewater. And I'm here on behalf of the Smiths. They are here with me. This is just to make it a little easier to see that overlay that I've done there. Some time ago, I think Rebecca from my office might have been here with a Form A, in which we created or took out 2 house lots from this overall parcel and left a parcel in the middle that was not a buildable parcel at the time. And then what we have before you tonight is a 2-lot subdivision with a hammerhead design, which would provide access to these 2 home sites which were lot 3 and 4 in the original plan. The drainage from the roadway would be funneled down or basically towards, there'll be a portion of it that gets collected about midway, then comes down to a point in which it goes into a basin, which is to the west. And then from that basin, there is also an overflow to a level spreader for that extreme event in which the basin doesn't handle the flow. It's a simple but effective way of dealing with the drainage from the site. It's only a 2-lot subdivision. It doesn't really normally have to meet the higher standards for drainage, but we have provided for what we do for a larger basin. The same way we have,
I apologize, that's not available.
we have basically treatment through a
EBCAM.
separator and then storage. And like I say, from here, there's a structure which will, if the basin ever gets to a certain height, it will overflow to a flow diffuser, which would then infiltrate along this and basically diffuse water along there to follow the contours that is naturally taking water in a sort of a northwesterly kind of direction. The overall, we provided, it's called Red Maple Path. We provided a set of plans, seven-page set of plans. This is the existing site is to the rear of the greenhouse operation that is along Plymouth Street. And the roadway layout, like I said, would be a 40-foot layout like it would be for any other road in town, except the difference is that you have on a 2-lot, you're allowed to do a hammerhead. And then we have the drainage easement that would be part of this lot 3, which is the one I described to you, would have the basin with the overflow to that side. There's really not a lot more to it. We provided all the details for the drainage part of it, the grading part of it, and basically I'd be able to answer whatever questions you might have. Our plans actually show road profile and so forth to meet all the regulations. So with that, I'd answer whatever questions you might have in terms of the proposal for the 2-lotter.
All right, so before we get to the board, Larry, just for clarification, these are both single-family homes with attached garages that you're proposing, is that correct?
Well, that is correct. That's how we illustrate them. That's how we determine how much we're expecting for runoff and so forth. I mean, the actual design of the house may change depending on who buys it, but we kind of lay it out for sort of the what we consider to be more towards the maximum side of what would be proposed versus a smaller house. And it could very well be a smaller footprint.
Okay.
Procedural question, if I could, Mr.
Mr.
Chairman.
Gardner, go right ahead.
Have you filed for the actual administrative part of stormwater permit with the DPW yet?
Don't know if I can answer that question. I could try.
Okay.
May have to.
Well, just a reminder, because for some reason, people are having a problem with the idea that when a plan is filed that clearly needs stormwater permit, although the plan comes to the planning board and the planning board is responsible for the approval piece of the actual drainage, there should be an administrative filing with the DPW because they're the one who keep the records and the approvals for the long-term maintenance requirements and so on and so forth, so.
But the timing of that would be after your approval, would it not?
They should be aware that it's being done. Technically, they're not.
Well, I would think that they'd be aware because once this is filed, it goes out to the
Right, so-
departments, right?
So the discussion we've had with the DPW and the Board of Selectmen, who technically are the stormwater management team, has been that it should be filed at the same time, and a copy of the plan should go to them as well. They do have access to it, obviously, but
Yeah. You would think that if that was the case, though, wouldn't you think that their comment back to this board would be saying exactly what you're saying, though? You would think that. I don't know, maybe I'm just, if that's what they were looking for, you would think that they would be
So
providing that for
I did
input.
wa-
But we will
while
make sure that that's what happens anyway.
All right, so, but in any case, there was one comment from, I don't know whether it was in this set of plans or not, but originally when we were having our discussion with our track meeting,
Yeah.
there was some comments made by DPW as they don't want to see curb cuts for either houses on the 40-foot piece of that hammerhead, because
And-
that's where they're going to put the snow.
On the 40-foot piece of the hammer, on
And
the,
I
on the,
think- They want it off the length of the hammerhead, not the 40-foot ends.
okay.
And I believe at least one of the driveways was shown
One
coming
of
off.
the driveways is shown coming off the end of the right side of the hammerhead.
Yeah, and the way that the town has to plow the hammerheads is they dump the snow right at that end,
Okay.
which would be right at the entrance to the driveway to that house.
So what we should show is a modification to the driveway location as it goes into lot 4, I think.
Take it off one of the sides, either the long side or the, what would be the south side or the north side, not the west side or the east side.
I'm sorry, off the what?
The south side or the north side of the road,
Yes.
whichever
Instead-
best fits the lot.
Right, okay. Understood.
There was some early discussion about changing it to a cul-de-sac to avoid that problem, but I think it's easier.
You stopped those people, right?
And the DPW was happy enough to say that if we don't take the driveway access off the end of that 40-foot piece on either side, we should be okay.
Okay, no, we'll make that
Because
adjustment.
whoever lives in those houses isn't gonna be happy every time the snowplow goes by and piles the snow up at the end of the driveway again. And that's exactly what they're gonna do.
Right. Yeah, so if I can keep it, yeah, we'll probably come off the north, I don't know which one we might come off. We might just change it a
The
little bit.
details you can work out, Larry.
Yeah, we can work that out.
Right.
We will work it out.
Yep, okay. Comments, questions from the members of the public? Sir, whatever you prefer.
I'm Aaron Pinsky, 7 Railway. On this map that you guys are looking at up there, not up here, I'd be the third house up. I'm interested in you have the 2 parcels, and were they restricted down to 3 parcels, 3 possible builds on that lot? I'm interested in the size of the square footage on the lots. Because that was part of the Lotus, I believe.
I think the answer to that is the overall total on that parcel, which was originally Lotus, will be 4 lots. I believe there's a lot on either side of the entrance.
Yeah.
It used to be the entrance to Lotus, and then there's the 2 new lots that will be behind that.
Right, when they did the calculations, they couldn't get 4 lots, it had to be down to 3 because of the square footages,
No.
you know?
No, I'm sure that's incorrect, because
That's what we determined last meeting.
the requirement for area for a lot in R1 district is 35,000 square feet, and they more than meet that on each of the 4 lots.
Yeah, but it got increased with, same thing with Ray Way, we don't have 35, we have all the extra area in the back of our houses as shared land in order to make up for that square footage on the plots.
Because Ray Way is what's referred to as a planned open space subdivision. These are 4 conventional 35,000 square foot lots.
That was not determined last meeting when we sat, and I had a conversation after the fact as well. That you guys determined that it was too small, that they had to up the size of it.
If I could.
Am I wrong?
Do you have an explanation there, Larry?
Yeah, what happened was, There was some discussion
Can you
about
bring up the
whether or
original,
not
can you bring up the
parcel-
original one back up here? So I can,
Yeah, let
the
me,
one that,
We're working on it, yep.
well, there's clearly more than 70,000 square feet in that big parcel where those two lots are gonna go.
yep, it's these two here that was, we were originally talking about. These are set up for 35,000.
Yep.
And it was increased in this area for 45,000. That was determined last time we were in here. That these had to be increased to 45,000, and if not, they'd be able to take this as shared land to make up for that. And with this, that they're proposing about the two houses out here now, at 35,000 square foot lots or whatever, it was determined that they could only have 3 lots because they had to be 45,000 square feet.
Are we in the watershed protection district?
Yes.
Yes. The actual calculation, as it relates, and it's shown on our plans, is that the overall parcel for which that calculation was to be done includes the land that was Ray's Way. So the Ray's Way subdivision, the land there, and these proposed lots here, the 2 Form A lots and the 2 in this 2-lot subdivision, in the aggregate, is how the calculations are made. We provided that information to the board back when the Form A was brought before you. And if you see on the faceplate, it's on the, I know it's on the grading page. But there's a notation here that says watershed protection district requires average minimum of 45,000 square feet. Plan book 45, page 834, Ray's Way. The overall parent property was 14.61 acres. Ray's Way has 9 lots, and these add another 4 lots. In total, there are a total of
13 lots with an
13 lots.
average of
With
48
an average
plus.
of 48,955 square feet. And I think before, the confusion is that we're looking, when they were looking at these calculations, they were looking at them as just this parcel of land, which had the 2 Form As, and the 2 lots to the rear, which is this subdivision that's before you. But it did not, that's not how the calculation is made, because it goes back to the original parcel.
All right, so we're gonna stop at that point, because that's gonna require a town council advice.
We provided this to this board prior to you endorsing the Form A. As a condition of us getting the Form A endorsed, we had to show that, and we showed that at that time. So to me, it's a moot point. That was something that was already hashed out. It was already
I don't
shown.
agree with that, because we haven't voted legally anything at this point.
You did, when you voted the Form A.
What is a Form A, Larry?
Well, the Form A was to create, at that Form A,
What
you,
is a Form A?
listen, I understand what a Form A is.
Approval not required plan that shows 150 feet of frontage. End of discussion. End of discussion.
No, because the discussion
End
was
of discussion.
about how much the square footage had to be on the lots. Because that question came up before as to whether or not the Form A lots would have to be larger in size.
No, they don't. But the average of the entire parcel, which is only this piece,
No, it is not.
not forever back as far as you want.
No, it isn't. It
Well,
isn't.
we're gonna disagree on that, and we'll get town council approval on that. We'll disagree on that.
We provided that.
So
We
you're saying you
provided-
can keep?
No.
Stop. All right, I'm speaking, please. You're saying that you can checkerboard this as long as you want and keep the open space that you saved for the first subdivision set that you did 20 years ago and keep Pac-Manning off of that for each of the ones down the road? I don't
That's
think
not what
so.
I'm saying.
But you can't use part of the open space on Ray Way
That's ours.
as this. Those
I
are
disagree.
two
I
totally
respectfully
separate
disagree.
legally
That's how it
parcels.
was created. When Ray's Way was created, this was a parcel that was part of Ray's Way.
It is Ray's.
It was
Way.
part of Ray's
It's
Way.
not part of your part.
Okay,
They were not a separate, this is not like going and taking other land and bringing it in. This was all part of a 14 point, whatever it was, 8-1.
All right, we'll have to
Awesome.
review that, because if that's what you're doing, then I misunderstood that. I thought that all of these added up with its 4, 5, whatever it is, acres total, gave you just enough square footage to get the 4 lots.
No, we made reference to the Ray's Way and the fact that this land is the final part of the overall parent property, which is 4.81. That's how it was calculated in terms of watershed protection.
But the people on Ray Way are the only ones that own that open land.
We'll have to go back and review all of that, because even though
I know we had the discussion at the time in January when we endorsed the Form A plans. I know that the information was provided to us.
Yeah.
And I specifically, I can't recall what it was. I remember, my recollection, to the best I can, I think is what Mr. Silva's saying, but
They said they were required to be at 45,000 square feet, not even 35.
Yeah. All right, we'll have to review that issue. We're not gonna go any further with it tonight, because that's a really complex land use matter that dates back over 20 years. Back 30 years, I
The
think.
people that own that parcel is the people on Ray Way.
Yeah.
Those are the only people that have access to it, and the only people that can use it. Are all the houses on Ray Way own it. We have our own,
Yeah, we'll have to, we're gonna have to review that further, so.
other comment from the public? Third and final time, other comment from the public with regard to the proposed subdivision, Red Maple Path. Hearing none, motion to close the public comment section of the hearing. Motion by Mrs. Tedesco, second by Mr. Heeger. All those in favor? Aye.
I'll vote in favor with the stipulation that we still need to review the details of
Yeah, that's just the public
How those
comment
lots
section,
were,
yeah.
it's
We'll
still
calculate it.
45,000 square feet lots, so that there should be no acceptance on any of this unless they're at 45,000.
So I
lots.
think that, well, let's,
I'll make a motion that we continue
Well, let's-
discussion
yeah.
of this subdivision till our next meeting.
let's have the members, if they have other questions or concerns while Mr. Silva's here, he can perhaps answer them, and then we'll do that. Rachel, Diane, any?
My only comment was that I'm a little confused now. I thought I understood what was being proposed, but now with Ray's comments, and not being aware of the history of this, I just don't know. So,
Miles?
No questions at this time.
Okay, so, Mr. Gardner, your motion would be to continue the matter until our next,
Our next regular meeting, which
next
should
regular
be,
meeting, which would be the 19th.
that sounds correct.
Yes.
So motion by Mr. Gardner to continue the public hearing until Monday, May 19th, 7:15 PM. Second to that motion?
I'll second that motion.
Seconded by Mrs. Tedesco. In the meanwhile, we will do some further investigation, and we'll get a determination on that question with regard to the overall Ray's Way subdivision.
If there's any of the information that you need that was forwarded to you when this was brought up before, just
I'm thinking it
contact
should
us
be in
and
the
we'll
other
get it.
folder that we have here, I would think, so, yeah. Okay, so that motion is on the floor. Further discussion there, hearing none. All in favor of the motion to continue the hearing till May 19th, 7:15 PM, so signify by saying aye.
Aye.
And opposed. Unanimous vote of all members present and voting. Correct. Thank you.
Thank you.
Okay.
Thank you, Mr. Silva. We will see you in 2 weeks. And last but not least, it being 8 o'clock, we have a final public hearing, that being with respect to a proposed bylaw amendment to section 5H2 of the zoning bylaws. Chair will declare the public hearing open at this time. Legal notice, the Planning Board, Town of East Bridgewater will hold a public hearing on Monday, May 5th, 2025 at 8 p.m. in the Town Office Building, 175 Central Street, large second-floor conference room, to consider an amendment to Section 5H2 of the zoning bylaws of the town to thereby permit residential uses on the second level of commercial buildings within a B3 zone. The full text of the proposed zoning bylaw amendment is available for review during normal business hours at the Planning Building Department, 175 Central Street, second floor. This was again published in the Enterprise on Monday, April 21st, Monday, April 28th. And Mr. Gardner, since this is kind of your genesis, I would just ask you for an introduction, and then we'll take public comment.
Yeah, so we have at least one applicant in 2 other existing buildings in B3 zones where they're allowed to build 2-story buildings, but there's no businesses willing to rent the second floors. The specific applicant here has a parcel of property that's down at the intersection of routes 27 and 14, I believe they are. Down near where the assisted living facility is. They have an approved building for what he thinks would probably be a 5-unit building in the first floor. Could be a 5-unit above in the second floor. But there's no one these days interested in renting those second floors. For the record, there was a situation in the town of Abington a while back where they had that same issue, and they changed the bylaw to allow second floor apartments on those businesses along street frontages. So the intent is to try and make the cost of the building work, basically. Doesn't make sense to build a 1-story building. The difference in price to build a 1-story building and a 2-story building is in terms of ratio is only 40% more supposedly to build a second floor on it because of the site work and all those other kind of things. So we had a discussion with that applicant. He suggested we consider doing that since other towns have been doing that. We looked into it. As we've heard earlier tonight, we desperately need rental housing in the town of East Bridgewater. The town is actually shrinking in population, even though we're building houses, quite a few houses. The average family size in East Bridgewater continues to drop and has been dropping continuously for 20 years. So we need to do something to allow people to still live in the town. This is another potential piece. It's not going to generate a significant number of units, but it will generate some business buildings that probably wouldn't get built without it. Those business buildings pay lots of taxes, which based on the way our budgets are done is to some extent free money to the town because they have virtually no cost to the town. So that's basically the intent of this proposal, to allow second floor apartments and business buildings in the B3 district.
Okay. That being an introduction, anyone in the audience with comments or questions? Ma'am.
Hi, Kathy Wolf, Laurel Street. I'm just wondering, what is a B3? What does that mean?
That's a business 3 district in the zoning map. Those are typically 200-foot zoning along mostly numbered routes.
Okay.
Routes 14, 27, there's some on 18, further down 18.
Are there any on 106?
I believe the B3 district on 106 is down in that area as you get to the railroad tracks.
Elmwood. Excuse me, Westdale.
Yeah, whatever the old name used to be. I'm not a long-term townie, so, but yes,
It was Westdale.
in the area of Johnny Macaroni's and the appliance
Yeah, I
store
live right
and,
there.
and that stuff.
Okay.
Oh.
So they wanna, yeah, I think it's a good idea personally. My very first apartment was above a business.
Third and final time, comments, questions with regard to the proposed amendment to allow further development in the B3 zone. Hearing none, take a motion to close the public comment section of the public hearing.
So moved.
Motion by Mr. Gardner, a second.
I second that.
Seconded by Mrs. Tedesco. All those in favor of the motion, so signify by saying aye.
Aye.
And opposed? Unanimous vote. Members of the board, Yvonne or Miles, any comments or questions?
No.
Ladies?
The only, this is for all
B3.
B3s, not just this one
Yes.
particular.
Yeah, we can't rezone for one specific parcel. It has to be a general rezoning to
Okay,
cover the district area.
yeah, I think it suits East Bridgewater to encourage housing.
Rachel?
I agree. I think that this makes sense. That it would encourage both small businesses and housing at the same time, so it would benefit.
Roy, anything further? No?
I don't have anything further at this time.
The chair would await a motion.
Make a motion to approve the zoning amendment as presented.
Motion is made by Mr. Heeger to recommend to the annual town meeting the proposed amendment to section 5H2 concerning second floor dwelling units. Second to the motion?
Second?
Seconded by Mrs. Phillips. Any further discussion? All those in favor so signify by saying aye.
Aye.
And opposed? Unanimous vote of all members present and voting. That concludes our list of public hearings for tonight. Is there anything further to come before the board? Ladies,
I don't have
gentlemen,
anything.
chair would entertain.
Make a motion to adjourn.
Just one quick, I'd like to thank Jason for his help on all of the proposals that he's done to multiple different places. I went to a couple of them, so we do appreciate all calling the planning council's support and help, and specifically the work you did to put those presentations together, so thank you.
Thank you.
Motion was by Mr. Heeger to adjourn. Is there a second to that motion?
Second.
Seconded by Mrs. Phillips. All those in favor, so signify by saying aye.
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 Opposed?
No.
Vote. Thank you. Good evening.